Okay, so first we're going to start with an article out of the newsletter. Anybody read the newsletter? No? Okay. Okay, for the record. At the beginning of the year, Humphreys College became Humphreys University, another milestone in the 120-year history of the first private institution of learning in Stockton. Since 1896, we have been serving Stockton and the surrounding communities with quality, affordable, and accessible higher education, and have undergone several name changes. Originally, when John R. Humphreys Sr. purchased an existing college and assumed leadership, we were known as the Stockton Business College, Normal School, and Telegraphic Institute. During his time, the college was focused on secretarial, business, and teacher education. In 1947, the school was reorganized as a nonprofit corporation, and the assets of the school were endowed to a public trust called Humphreys College. It continued the traditions of small, personalized, and relevant education. The goal of Humphreys College, in the words of then President John R. Humphreys Jr., was to serve a small group of people very well. In the years and decades to follow, Humphreys College maintained its mission of high-quality, personalized education while continually adapting to the needs of the community. The normal and technical school evolved into a degree-granting, liberal arts-based college focused on career education and emphasizing practical, hands-on knowledge. In 1951, a law school was created to offer a 4-year night program to aspiring attorneys. Institutional accreditations marked further progress in 1972 with WSCUC Junior Accreditation and 1992 with WSCUC Senior Accreditation. A branch campus was established in Modesto in 1987, offering 2-year programs, and recently expanded to offer 4-year programs as well. In 1966, the school moved from downtown Stockton to its current location. Campus extensions followed in the ensuing years until 2011, when the South Campus was completed, replacing a dorm facility that was constructed in the 1970s. In more recent times, the college continued to adapt and advance with the development of its first graduate level program, a Master of Arts in Education. Shortly thereafter, we returned to our roots with the addition of a CTC accredited teacher preparation program. In 2014, Humphreys expanded its offerings to include degree completion programs in Los Angeles and Sacramento, serving international students. Currently, we are developing additional graduate level degrees and the first entirely online program. Today, the institution comprises 4 campuses in as many cities and offers certificate and degree granting programs at the undergraduate and graduate level, many with specialized program accreditations, and all with regional institutional accreditation. While we remain committed to our original core values and mission of providing affordable, accessible, and personalized education in career-oriented subjects, we have outgrown the title of college. 2017, our 121st, is the year of Humphreys University. So I wonder if this, I'm looking this way, if they're going to be able to, I'm not going to know until we redo this to see. Okay, we're going to do some straight matter and jury charge takes today. Ready? For the record, good afternoon. I am happy to be here this afternoon to discuss something that is important to all of you, your memory. Memory is something we take for granted until we lose it. During the next hour, I will present some tips that hopefully we'll never forget. When my husband Ted started losing our car, I began to worry. In his 30s and 40s, he'd leave a store or a theater and head straight for our car with no problem. However, just after his 50th birthday, Ted walked into a mall parking garage and stopped short. Scratching his head, he asked, "Where did we park?" Over the following months, there were occasions when Ted would forget where he put his glasses, his keys, and his wallet. Walking by a restaurant one day, he remarked, "Remember what a delicious dinner we had there?" I had never been in that restaurant, and I said so. Well, he insisted. He had ordered the sole, and I had the salmon. He even said we had both agreed it was one of the best restaurants we had ever been to. Although I found Ted's memory lapses troublesome, many experts say that forgetfulness doesn't really signal trouble. There's no need to worry about these lapses until you are having a marked and consistent decline in memory or you aren't able to function at work. At that point, of course, make sure you see a physician. For many people, such lapses are just a normal, if annoying, part of life. Mild deficits in memory do begin in the 40s and 50s, and they increase in later years. But fatigue, stress, and a mere lack of attention all can trigger brief memory loss in people of all ages. I am going to talk about some common types of forgetfulness and some strategies for minimizing them. How many times have you said, "Wait, it's on the tip of my tongue"? You start to introduce an old friend to someone and suddenly you can't remember that someone's name, even though you sense it just beyond the grasp of your memory. Do you remember the name of the movie you just saw? It's in your memory, you just can't retrieve it. Doctors tell us such tip-of-the-tongue incidents happen almost to everybody. These lapses have nothing to do with remembering the meaning of a word, but rather with its sound. Many doctors who have studied memory loss indicate that frequently the sound of a word has no rhyme or reason. The sheer senselessness can sometimes make word recall difficult. The best way to prevent the problem is to use the name of a person or object as often as possible. I tell my clients to do what salespeople often do. They repeat a person's name several times before planning to see them. A tip-of-the-tongue experience can seem worse when a similar sounding but incorrect word pops into your head and stays there. There was a student in one of my classes who was trying to recall the name of a particular motorcycle. The student wanted the word cruiser, but she could only come up with crooner. When this happens, you should shift your focus to something else. If you stop fretting about it, the correct word will eventually come to you. This afternoon before you came here, did you think, "Where did I put my keys?" Most episodes of forgetting where you left something or wondering why you just entered a room result from a simple lack of attention. You are supposed to recall something, but you have not encoded it deeply. Encoding is a special way of noting events that may have an impact on recalling them later. Failure to encode events can set you up for trouble. If you put a cell phone in your pocket, for instance, and you don't pay attention to what you did because you're speaking with someone, you'll soon forget that the phone is in the jacket now hanging in your closet. Your memory, per se, isn't failing you. Rather, you didn't give your memory system the data it needed. Lack of interest can also lead to memory lapse. A man who can recite baseball scores from 30 years ago may not remember to drop a letter in the mailbox. Women have slightly better memories than men, maybe because they pay more attention to their world, and our memories rely on just that. Visual cues can help prevent some short-term memory lapses. However, you should be certain that the cue is clear and available. If you want to remember to take some medication at lunch, put the pill bottle on the kitchen table. Don't leave it in the medicine chest and write yourself a note that you tuck into your shirt pocket. There are times you may suffer memory error. You recall correctly an event, but attribute it to the wrong source. For example, you share a story with a friend and you credit it to your mutual acquaintance, Jim. Though the incident happened to Robert, from whom you heard it in the first place, you remain convinced that you heard it from Jim. False memory is another trick the mind can play. You may remember that you tumbled out of a rowboat when your grandfather took you fishing, but in reality, you only observed such a scene in a movie many years ago. As annoying as these kinds of memory lapses can be, there is a positive side. If our brains stored all that we saw, heard, or read, we'd be overwhelmed. Our ability to splice together bits of required information and throw out the rest is essential for sound thinking. I find that comforting. Now, when my husband forgets where the car is, I just tell myself that he is busy storing the data that's important to him. And when we pass that restaurant, I smile and let him savor that unforgettable meal. Okay, here's a legal straight matter. For the record, this is known as a copyright and trademark case. Now, ladies and gentlemen, to be very specific, there are two items that are involved in this case. One is known as copyright, the other is known as federal trademark and unfair competition. So there are two claims made by the plaintiff against the defendant. Everything else has been dismissed. Everything else has been ordered back to the lower court. Now, what is copyright? Well, most of you have seen the little C's that are put on packages or cartons, some very artistic in nature. It means copyright. Now, copyright is a bundle of rights that a person originates and obtains with respect to a certain thing. The copyrighted item must be original. Among the rights are the rights not to have somebody copy or make a facsimile of it. In other words, lookalikes are not permitted. The copyright owner is entitled to be free from all attempts to counterfeit and copy, and if he isn't, he can sue for it. If he does sue for copyright, as in this case, there is a liability on the part of the defendant for violation of a copyright. The copyright owner can claim actual damages for copyright infringement. What does the copyright owner have to do? He's required to present proof only of the infringer's gross revenue. That's the way copyright law works. The copyright owner must also prove that the copying or infringing took place. If it's sold, it took place and infringement exists. The only problem is to determine damages. All right, let's turn to trademark. Trademark is also a bundle of rights. Trademark includes any word, name, symbol, or device, or any combination thereof adopted and used by a manufacturer or a merchant to identify and distinguish his goods. Coke has its own trademark. Pepsi Cola has its own trademark. McDonald's has its own trademark. Unfair competition is akin to trademark. That means it is illegal to trade on a name of a product and mislead the public that someone else is the manufacturer rather than the holder of the trademark. Copyright and trademark are closely related. This case, then, is a case brought by the plaintiff for alleged violation of the copyright laws by the defendants. The plaintiff additionally alleges violation of trademark, including unfair competition by the defendants. The only question before you will be damages by reason of defendant's violation as the proximate result. The topics are closely related, but should be dealt with separately. All right, let's do some jury charge. About 185. Okay, here we go. For the record, ladies and gentlemen, as your name is called, please answer here and take your seat as directed by the bailiff, beginning in the back row in the corner. Those of you who have not been chosen are excused to report back to the jury commissioner. Thank you very much for your help here this morning. Ladies and gentlemen, you have been sworn as the jury to try this case, and I would like to explain your function, the role of the court, and the part each of the lawyers will play during the trial. During the trial, you will be the judges of the facts, and I will decide all the questions of law that arise. At the end of the case, I will instruct you on the law that governs this case. It is the duty of the lawyers to present their clients' cases in the most favorable light. Therefore, arguments and comments of counsel are not evidence and must not be treated by you as evidence. You are not to discuss this case among yourselves or with anyone else during the course of the trial, and you will not permit anyone to talk about the trial within your hearing. You are not to visit the scene of the alleged crime, and you must also avoid the appearance of any improper conduct. I caution you not to talk with any of the parties, the lawyers, or the witnesses at any time during the course of the trial, even about matters unconnected with the case. And if anyone should approach you about the case in any manner, please report it promptly to one of the bailiffs. You are not to form any opinion regarding the case until you have received all of the evidence, heard the arguments of counsel, and have been instructed as to the law to be applied in this case. In order that you decide this case only on the evidence presented, I direct you not to read, listen to, or observe any radio, newspaper, or television accounts of the trial while it is in progress. I will be ruling on the admissibility of evidence and the propriety of questions asked of the witnesses during the trial. You are not to be concerned with the lessons for these rulings or attempt to draw any inferences in favor of either side. My rulings will simply be based upon the law. Do you understand that? You will be the sole judges of the truthfulness of each of the witnesses. In deciding what weight is to be given to the testimony of any witness, you may consider his ability to observe, his memory, his manner while testifying. You may consider any interest he may have in the outcome of this case. In a criminal case, it is the state's burden to prove the defendant guilty beyond a reasonable doubt. Reasonable doubt means a doubt based upon reason. It is not an imaginary doubt or possible doubt. Reasonable doubt is a doubt for which a reason can be given arising out of an impartial consideration of the evidence or the lack thereof. The clerk will now read the information and state the plea of the defendants. Will all of the witnesses who are here at this time come forward and give your name to the clerk to be sworn? Ladies and gentlemen, the rule for the exclusion of witnesses has been imposed, which means you are to remain outside of the trial while it is in progress until your testimony is required, and then you will be sent for. You are specifically instructed not to discuss your testimony either before or after you give it with anyone except the attorney who had you come here. Ladies and gentlemen, we will take our morning recess. Please remember not to discuss the case among yourselves or with anyone else during the entire course of the trial, and do not reach any conclusions until you have heard all of the evidence. You have heard all of the arguments of both counsel, and you have been instructed by the court as to the law in this case. We will resume at 2 p.m. The record may show the jury's presence. We will waive the roll call. The defendant is present with counsel. Will any witnesses who have not been sworn come forward and be sworn by the clerk at this time? Counsel, you may call your first witness. Okay, I'll just do a few more minutes of another jury charge and then we'll start takes. Let's see. Okay, ready? For the record, having been chosen and sworn as members of the grand jury, you are now officers of this court. Your duty and function is to aid and assist in the administration of public justice throughout this county. As such officers, you are to investigate any such matters as might be called to your attention by the court or submitted to your body by the district attorney, or of which you may become cognizant during your inquiry, or which might be reported to you by your associates. Your body ought to find an indictment in every case submitted to you, which, in your judgment, the evidence before you, if unexplained and not contradicted, would warrant a conviction. Your oath requires you diligently inquire and true presentment make of such matters and things as may be given in your charge or might otherwise come to your knowledge during your present service. The law asks this of you, and the law requires that if any grand juror knows or has a reason to believe that an offense can be tried by the district court of the county that has been committed, he shall declare such fact to his fellow jurors who may investigate it. In the investigation of charges or matters brought before your body, you should receive no other legal evidence than such as given by witnesses produced and sworn before you, or furnished as legal documentary evidence or other physical evidence. You are not to base your findings, whatsoever they may be, upon reports, suspicion, or hearsay. A grand jury shall hear all the evidence presented by the district attorney. It may hear evidence for the defendant, but it is under no duty to do so. In the course of your investigation, if you should have reason to believe for any cause whatsoever there exists any other evidence not before you but within your reach, which would qualify or explain the charge under investigation, it would be your duty to order the evidence produced for your consideration. Your object is to ascertain the truth, and in the pursuit thereof, you have the right to examine every witness who may be able to throw some light on the subject of the investigation. However, you are in no sense to try a case or hear witnesses for the defense to determine the guilt or innocence of the person or persons under investigation. In doing so, you would be substituting your judgment for that of the court, depending upon the nature of the offense and for which the law has created another distinct tribunal. To intrude upon the province of the court as the sole judges of the guilt or innocence of the person or person charged or suspected of the crime, that would constitute a perversion of the purposes for which this grand jury is created, namely as an accusatory body having its particular place in the administration of justice, and would be a violation of your oath. As a grand juror, you alone shall determine the weight and credibility of the evidence. As the sole judges of the credibility of witnesses and of the weight their testimony deserves, you should scrutinize carefully the testimony given and the circumstances under which the witness has testified. Whew. How'd you do on that? Was it a push? I hope. Pushed me. Okay. Let's start takes.